over the session to the panel that has been constituted. Our session chair is no other person than Dr. Alex Izion, Senior Advocate of Nigeria. He's here with us at the Secretariat. I will hand over proceedings to him at the appropriate time. And then we have the lead presenter, who is Mr. E.C. Ukala, Senior Advocate of Nigeria. Mr. Ukala is joining us virtually from his office in Port Harcourt, I've been made to understand. Mr. Ukala, can you hear us? Mr. Ukala?
Hello?
Mr. Ukala, can you hear me?
Yeah, you are quite faint.
Mr. Ukala, can you hear me? Is it better?
You are very faint.
Is it better? Can you hear me?
They have not unmuted.
Can you hear me?
Well, I can hear you just very faintly.
Wow. It is quite faint.
And somebody keeps muting me. I don't know.
Can you increase the volume? Can you increase your volume of your, maybe from your
I've
device?
increased my volume to the highest.
And we can hear you perfectly. We can hear you perfectly.
You can hear me perfectly?
I can hear you on loud.
That's great. If you can hear me, carry on.
Oh, okay. So, welcome, sir. Yeah, welcome, sir. We also have...
Thank you.
We also have DC Denwigwe, Senior Advocate of Nigeria, with us. He's joining us virtually from Owerri. Leonard Silk, please, if you can hear us, please, can you confirm if you can hear me?
I can hear you loud and clear.
Thank you. You're very much welcome.
Hello?
I can hear you, sir.
Thank you.
Thank you. And then
in-house,
we have with us another eminent Senior Advocate of Nigeria, Sam Ologunrisha, Senior Advocate of Nigeria, is here. He's seated right next to the chairman of the occasion. He will also be intervening on this topical issue of latest developments in criminal procedure. So the only person who will be joining us physically in the Secretariat is Mr. Chino Obiagu, Senior Advocate of Nigeria. He will join us shortly. He will be physically with us. So without much ado, Mr. Chair, I hand over the session to you.
Good afternoon, ladies and gentlemen. Welcome to today's section, the second day running for this program. We have an exciting time today because of the topic, judicial update and legislative development. Recent development in criminal procedure, part 1 and 2. I hope you are hearing me.
Yes, I'm hearing you.
Okay. So you are welcome to this section, and it's very loaded. I'm very, very humbled to be invited to preside over this section because I have eminent scholars who will be delivering the papers. We have the lead presenter 1 and 2, E.C. Ukala, Senior Advocate of Nigeria, will deliver the first paper. And then my brother DC Denwigwe, Senior Advocate of Nigeria, would present the lead paper 2. The interveners, the panelists, we have our 2 brothers here, Sam Ologunrisha, Senior Advocate of Nigeria, and Chino Obiagu, Senior Advocate of Nigeria. Today's section is really well loaded, and I don't want to preempt, but I think for put in a literary way, at the time we hear from them, if we're possible to do some Michael Jackson breakdowns, I think he will do it because they are very, very thorough. So let's kickstart. The two lead presenters will have 30 minutes each to speak to the papers. And then the interveners will have 15 minutes to discuss the papers, and let's have their own view too. And thereafter, we'll do the summing up. So without wasting time, I will like to yield the floor to, I don't know whether Mr. Isu Kala, Senior Advocate of Nigeria, whether you are ready now for us.
Mr. Chairman, yes.
Oh, okay. So we yield the floor to you because, like I said, all of you is an important opportunity for people hearing. They just want to hear. You are not a horse. All of the discussants at the panel, they are not horses. But they want to hear from the horse's mouth, as he said. Because maybe there is something in the horse that nobody has ever seen. So we want to hear that from the horse's mouth. So over to you. Thank you. 30 minutes.
Thank you very much, Mr. Chairman.
Thank you.
I'm honored to be invited on this occasion to make this presentation. In a constantly evolving world, it is imperative at intervals that our reflective minds question and appraise the state of the law in our criminal jurisprudence, which is ever growing. If we are ever going to achieve the hope of obtaining justice, which on its own is the only guarantor for peace and possible vaccination against the emergence of the Hobbesian state. It is therefore with great pleasure that I welcome the opportunity extended to me by the governments in the form of legislative activities in virtually all departments, including substantive criminal law, criminal procedure, and other aspects of criminal justice system. There have also been a few judicial pronouncements that have impacted on existing statutes, such as to render one or two sections of the statute null and void. We have identified 10 legislative developments for the purpose of our discussion in this paper. Our list is far from being exhaustive, but they include coronavirus, the Quarantine Acts and Regulations, that is for coronavirus. We have Coronavirus Practice Directions. We have Nigerian Correctional Service Act. We have Suppression of Piracy and the Maritime Offences Act. We have Kaduna State Penal Code. We have Imo State Administration of Criminal Justice Law. We have Nigeria Police Act. We have Administration of Criminal Justice Act. We have Companies and Allied Matters Act. We have Mutual Assistance in Criminal Matters Act. Now, under the coronavirus, which is the Quarantine Act and Regulations, we have discussed a number of issues. First is that the Quarantine Act which came into existence on the 27th day of May, 1926, was obviously challenged, faced with the situation that we met when the coronavirus pandemic happened. It was enacted for the purpose of regulating the imposition of quarantine and to make other provisions for preventing the introduction into and spread in Nigeria and the transmission from Nigeria of dangerous infectious diseases. In the 2020 quarantine, in 2020, the Quarantine Act had become 94 years old. It is obvious why the challenges that was posed by coronavirus pandemic became very obvious. In response to the challenges, both the federal government and state governments responded with various regulations to meet health and safety requirements of the citizenry. We have highlighted some of these regulations, including the Lagos State regulations, the Ekiti State, other provisions, including that of the federal government. We have also highlighted the trial of persons under the nations, including the trial and conviction of popular Nigerian artist Funke Akindele. A number of legal issues or legal challenges, regulations pending in our law. It is to discuss matters that are pending before the court. The question whether regulations are lawful, constitutional, will await the outcome of pending litigations. Now, the other very impactful legislation within the period is the new practice directives that were given in light of the coronavirus challenges. The new practice directions were also introduced to meet the challenges of lockdown, restriction of movement, and limitation of gathering in the wake of the pandemic. New developments introduced into litigation practice, including criminal procedure, e-filing, e-services, and virtual sitting of proceedings are now part of our legal practice reality. We have highlighted some of the guidelines and practice directions in the paper to include guidelines for court sittings and related matters in the COVID-19 period issued by the Nigerian Judicial Council. We have the Federal High Court Practice Direction 2020 for the COVID-19 period, which was issued 15th of May 2020. We have the National Industrial Court Practice Direction and Guidelines for court sittings of 18th May 2020. We have the Lagos State Practice Direction for remote hearing of cases, April 2020. And then we have the FCT High Court COVID-19 Practice Direction 2020. Progressive and laudable as these guidelines are, it is difficult to determine at this stage. It is difficult to determine at this stage whether they will stand the test of time, especially given constitutional scrutiny in view of the provisions of Section 36, subsection 3 of the Constitution and the earlier interpretation given to by the Supreme Court in a number of cases including Edebo and the state, as well as the provisions of the Sheriff and Civil Processes Act. You should remember that when we are talking about e-filing and e-service, we are actually talking of matters, especially e-service. It's a matter that is supposed to be covered by the Sheriff and Civil Processes Act. And if you have a situation where a state high court or anybody is introducing e-service, which is not recognized by the Sheriff and Civil Process Act, it is likely to pose problems. Now, we also have another piece of legislation, which is the Nigerian Correctional Services Act 2019, which was signed into law on the 31st of July 2019. It has been hailed by advocacy groups, legal experts, and prison reform activists for its attempt to establish international best practices in correctional services provision in Nigeria, including sleeping standards and accommodation of inmates as introduced by Section 9, notification of and action on overcrowding introduced by Section 12.4 and 12.7, Section 34, separate facilities for women or female inmates, and adequate facilities to address special needs of female inmates, such as pregnant women, nursing mothers, and their babies. Section 12.2c empowers the Chief Judge of a state to commute a death sentence to a life imprisonment where the inmate has exhausted all rights of appeal and has been imprisoned for more than 10 years without execution. The provision may not pass without controversy, especially in view of the constitutional arrangement regarding the finality of the decision of the Supreme Court. It is difficult to understand how a chief judge can go to prisons to go and reverse, as it were, a decision of the Supreme Court. Provisions for restorative justice under Section 43(1) of the same Act is also very commendable, but without being incorporated into the ACJA, that is Administration of Criminal Justice Act, it is difficult to see how effective it will be in practice. We will now leave that and move on to Suppression of Piracy and Other Maritime Offences Act, which we refer to as POMO. This was signed into law on June 24, 2019. The main aim is to tackle the menace of piracy, armed robbery, and other violent crimes on Nigerian territorial waters. This is against the background of the sad fact that 95% of global maritime kidnappings occur in the Gulf of Guinea. The jurisdiction of the court for trial of SPOMO offenses is vested in the Federal High Court as enacted by Section 5, subsection 2 of that Act. Section 12 provides for stiff penalty for offenses under the Act, including life imprisonment and a fine of not more than 50 million in addition to restitution in respect of individual offenders. For corporate offenders, fine of not less than 500 million to be paid by the corporate body, not less than 15 years for those responsible for the management and control of the company at the time of the commission of the offense. Then Section 19(1) provides for establishment and maintenance of special fund for this piracy and maritime offenses. The question is, how constitutional is this provision in view of the provisions of Section 162 subsection 1 of the Constitution. We will move on to Kaduna State's Penal Code Amendment Law. The only purpose of this amendment, which is basically a 2-page document, signed into law by Governor El-Rufai on the 11th of September 2020, is to impose very stiff penalty for offense of rape, which now attracts punishment of surgical castration and death for male offenders, and salpingectomy, surgical removal, which is the surgical removal of fallopian tubes, and death for female offenders in certain circumstances. The amendment has attracted very harsh criticisms, especially on the basis of its perceived barbaric nature. Novel as it is in Nigeria, there is no doubt that there are other countries where such punishment, at least some part of that type of punishment, is imposed in certain circumstances. One major country that comes to mind here is Czech Republic. In Czech Republic, surgical castration has been a part of their criminal law for sexual offenses for more than 20 years now. In the USA, some states permit physical or chemical castration, not surgical, though those ones are reversible under certain circumstances. In Ukraine, surgical castration is also allowed. The question that bothers us is, what is the rationale of engaging in very expensive surgical procedures for a person who has been condemned to death in any event?
Brother,
he still has to die. So you first of
15 minutes.
have to spend the money of the state on him, go through very
15 minutes.
complicated surgery, and then at the end of the day, you keep stand that the matter is also in court, so we'll not comment on it. Now we have the Imo State Administration of Criminal Justice Law, number 2 of 2020. This was signed into law on the 11th of March 2020. The law is substantially similar to the ACJA, which has become Nigeria's model law on administration of criminal justice. Curious and controversial provisions introduced into Nigeria's contemporary jurisprudence by the law are sections 484 and 485, permitting detention of persons during the governor's pleasure. Such provisions usually featured in criminal ordinances imposed on conquered territories by the British colonial regimes. They were notorious for being used as reins for those perceived as challenging the authority of colonial masters. We need not say more on this one. Nigeria Police Act. This features a number of innovative provisions, including Section 4, Sub 1, which introduces vetting and registration of private dictative schools and outfits. Then there is the electronic and manual database of records of arrests at federal and state levels, which is introduced by Section 47.5. There is inspection of police stations and places of detention by magistrates other than prisons at least once a month, which is introduced by Section 70, subsection 1. Now, if these provisions are implemented, there is no doubt that they will change the face of policing practice in Nigeria. We are all still trying to come out of a recent devastating demonstration, which was tagged EndSARS, which was simply in place because of the fact that the police is accused of not having to do what they were required to do in law to comply with observing human rights of citizens. Now, I'm sure that if these provisions were being implemented, or that they were in place and being implemented, a number of such complaints would not have arisen. So these are very useful provisions we have here. We've cataloged quite a number of them for you in the paper, which is quite detailed on this. Now, the new provision of powers of police to prosecute before the court those offenses that non-qualified legal practitioners can prosecute, as contained in Section 66(2), will remain a subject of discussion for a while until the courts are able the effect of that provision. We say so because we are not yet aware of those who are regarded as non-qualified legal practitioners, because the Legal Practitioners Act has definition of legal practitioners, but did not have definition of non-qualified legal practitioners. So I don't know how we are going to determine who falls into that category. But if that means that all policemen are entitled to prosecute, well, it has been a matter of debate for a while now, the issue of the propriety or otherwise of allowing the same police that investigates to also be the one to prosecute. And this will continue for a while. We don't know when this issue will be resolved, but we must say that the Supreme Court has already said that the police can prosecute all the way up to the Supreme Court. Now, we also have the Administration of Criminal Justice Act 2015, which you are all very much aware. It's nothing new there. The only thing that has arisen is that that act has now lost Section 397 of that act due to the recent decision of the Supreme Court. The Supreme Court, in the case of Udogo versus FRN, we supplied, well, it's not yet been published, but it was delivered on the 8th of May 2020. The Supreme Court held that Section 396 sub 7 of AGJA is unconstitutional. By the decision, Section 396 sub 7 of AGJA, which permitted the Justice of the Court of Appeal to attend to his unfinished duties at the High Court with regards to certain criminal proceedings, no longer exists. So that section is as good as dead, does not exist anymore. So that is the development there that you need to note. Now, we have also looked at the Companies and Allied Matters Act 2020. We have highlighted quite a number of provisions in it, but in this presentation, I will just mention a few. Section 11 of that act permits the Registrar General and other legal practitioners employed by the Commission to represent the Commission in court. Now, the question might be, would that entitle them to prosecute criminal offenses arising from there? You may find that the answer to that in the general powers of the Attorney General of the Federation, who, notwithstanding everything that has been said in that section, is entitled to prosecute offenses under the Act and give directives on who to prosecute, on how to prosecute. In other words, we are referring to section 675 sub 5, section 737, section 3727, then section 365 sub 2, where the Honorable Attorney General of the Federation is empowered to prosecute offenses under the Act or to give directives on the prosecution of such offenses under the Act. Sections 734 and 868 are all offenses under the Act which must be tried by the Federal High Court. In other words, all offenses under the Act must be tried by the Federal High Court within the jurisdiction where the offense is alleged to have occurred. In other words, the practice of sometimes arresting somebody in Abuja and charging him in Ibadan is not approved by the provisions of the Companies and Allied Matters Act. Various sections of the Act create offenses which may seem inchoate in view of the fact that penalty or punishment for the offenses are not clearly defined, but left largely to the discretion of the court or the commission. I think that the definition of crime would require that the punishment is also known. Now, in a situation where you're leaving virtually everything to the court to say decide how much you are going to fine, it's a bit difficult to understand how the courts will eventually take it. Whether, if it is challenged, whether they will stand, because what we used to know is situations where the provision says you are to be fined not higher than this amount or not lower than that amount, but to leave it entirely at the discretion of the court or the commission is something that is new to us. We don't know how it is going to play out in the courtroom. Well, we have cited a number of sections in the paper, including sections 83, 236, and 865 sub 5, which show these provisions we are talking about. Then we now move on to the last segment, which is the Mutual Assistance in Criminal Matters Act 2019. The Act was signed into law on the 1st of June 2019. It is to enable Nigeria facilitate and obtain mutual assistance in criminal matters, including criminal investigation, tracking of suspects, tracing and freezing of assets suspected to be proceeds of crime, among others. Through this act, our law enforcement agents now have a firm legislative platform on which to effectively cooperate with their foreign counterparts for the purpose of carrying out their mandate of fighting crime and prosecution of criminal suspects where such involves cross-border activities. I will now be concluding. In conclusion, we say that indeed Nigeria's criminal jurisprudence has experienced significant developments in the last 12 months, particularly with the enactment of the Nigeria Police Act, the Nigeria Correctional Service Act, and COVID-19 guidelines and practice directions, providing for virtual remote court sittings. Whether these innovative provisions embedded in the various legislations will accomplish their purpose largely depends on their successful implementation and enforcement by the relevant authorities. Let me just add that after we had submitted this paper, the Banking and Other Financial Institutions Act was also passed into law. I guess you would want to check for yourself to see whether there are provisions there that would be useful in a paper like this. So on the whole, I thank you very much for listening to me. Thank you very much, Mr. Chairman.
I think Mr. Isi Ukala, Senior Advocate of Nigeria, deserve a more and a bigger, louder applause.
Yeah. Can you hear that?
You know, within the compass of 30 minutes, he didn't even see that. He was able to speak to the paper. It is very well researched. And the sources, and if you take details to go through, you will know that it took time. We want to thank you very much for the industry, the sacrifice in going into all this. And it's a well-resourced resource material for us and all stakeholders. It's a must. So I'm sure that you just spoke to it, but we have what you have written. It's left for us to go back and read them, digest them, pontificate where necessary, because you've raised some fundamental issues there. So we want to thank you again, and God bless you for your services. They cannot be quantified monetarily, but you are doing us proud and service to mankind. Thank you again. We will move quickly to the next presenter, lead presenter. Mr. D.C. Demigwe, Senior Advocate of Nigeria, will be giving us part 2 of this paper. I don't know whether this is online already. Is it with us?
Yes.
Oh, okay.
I'm with you.
All right. We are ready for you. Like I said initially, I said, you know, the horse's mouth. The meaning of horse's mouth is authentic, authoritative. And the history behind that is that horses are not common. They don't move anyhow. When they talk, when they anything. So anything coming from them is authentic and authoritative. So we're listening to another speaker, my brother, D.C. Demigwe. So the floor is for you now to, within 30 minutes, to speak to us. You're welcome.
Thank you, Mr. Chairman. I start by showing and expressing appreciation for the opportunity of participating at this level. And I want to take a time actually to appreciate my learned brother Isi Ukala for the detail which he has manifested in his presentation. I feel dwarfed, I must confess. Now, the subject matter in consideration requires us to present a review and analysis of recent developments in the administration of criminal justice in Nigeria. I take the liberty to assume that most states of Nigeria have subscribed or domiciled the Administration of Criminal Justice Act, which was enacted and signed into law by His Excellency the President of the Federal Republic of Nigeria as a standard for the administration of criminal justice in Nigeria. I want to draw attention most pointedly to the stated aim and objectives of the adoption of the ACJA, which is to say, in section 1 and sub 1 and sub 2, says the purpose of this act is to ensure, I emphasize the word ensure, that the system of administration of criminal justice in Nigeria promotes efficient management of criminal justice institutions, etc. And in subsection 2, it says again, shall ensure. Now, what that calls my mind to is the fact that we often have enactments which are so beautiful in their nature, but we are not able to actually give full effect to their meaning. Earlier in the day, I listened to the expression of worry by one of the presenters to the effect that the courts have continually pronounced upon the fact that the police is not a debt collector. But in spite of those decisions, the police still keeps indulging in the act. So I think the intention of this law is that we should move to the next level, the level of not just having the statute on the paper, but also it's a charge on the courts and all the affected institutions to ensure obedience to the pronouncements of the purpose and actualization of the purpose of this statute. Now, my learned brother has alluded to the provision of sections 484 and 485 sub 1 to 3 of the Imo State ACJL, which pretends to donate powers to the governor of the state to detain people at his pleasure. Now, I was privileged to be in a location at the opening of the legal year for Imo State, where the Chief Judge invited so many legal luminaries to express themselves on the provisions and application of the ACJL of Imo State. The Honorable, the Attorney General of the state it was placed on the center of criticism on that occasion. And he explained that definitely that provision is a slip and not actually intended to be so. He blamed it on the draftsman, and I prefer to feel safe if that is the reality. But what is left to be done is that there should be an amendment to remove the dangers of any stray implementation of that provision. Now, I have taken the liberty to insist that the testing ground for the efficacy of any legislation in Nigeria is the law courts, by virtue of the exclusive investment of the judicial powers of the state, that is Nigeria, at all levels in the courts by Section 6 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Now, on account of this statement of the law, the search for new developments in the administration of criminal justice in Nigeria should lead us into an examination of some outstanding, remarkable decisions of the courts in criminal cases. The approach chosen herein shall be to identify decided cases with a view to focusing attention on the subject enactment which they dealt with. We shall choose the subject decisions in no particular order. We shall also comment on how the decisions achieved or failed to achieve the objectives of the statute. Naturally, the statutory point of call shall be the Constitution of the Federation, as well as the ACJL and the other related enactments which are regulated administration of criminal justice. And I proceed to identify some cases which I consider to the purpose of the occasion. The first port of call is the case of Ude Jones against FRN, which is unreported in the judgment of the Supreme Court dated 8th of May 2020 in appeal number SC 622C/2020. The case has been identified here as a forerunner, not because of the dramatis personae, but because of its vast coverage of subject of interest. The decision of the full panel of 7 of the justices of the Supreme Court of Nigeria is unanimous. It is particularly impossible to resist the demand for copious quotations from the salient decisions in that appeal. For lack of space, the quotations are limited to excerpts from the lead judgment of His Lordship Justice Ejebieko. The brief statement of the relevant facts of the case is that on the 31st day of October 2016, at the Federal High Court, Lagos Division, the appellant and 2 others were arraigned before Honorable Justice M.B. Idris, Judge of the Federal High Court, on several criminal allegations or charges. They each pleaded not guilty to all the charges. The trial on the charges proceeded, and after the prosecution had fielded 19 witnesses and closed their case on the 11th day of May 2018, the appellant entered a no-case submission. On the 17th day of July 2018, the prosecution filed their written address in opposition to the no-case submission. Before the court could deliver its ruling on the no-case submission, the learned trial judge was on the 20th day of June 2018 elevated to the Court of Appeal, and he took his oath as a justice of the Court of Appeal on the 22nd day of June 2018. Consequently, Honorable Justice M.B. Idris ceased to be a judge of the Federal High Court. In the ordinary course of events, the case should revert to a de novo trial by another judge of the Federal High Court. It would then call for a fresh plea to the charges, and the 19 witnesses or whatever number of witnesses the opposition may choose to call would have to testify afresh. It should be noted that it took the whole long time between the plea to the charges on 31st day of October 2016 through the filing of written addresses by the prosecution or the prosecution to on the 27th day of June 2018. Sorry, I take it again. Through the filing of the written addresses by the prosecution or the subscription to oath on the 27th day of June 2018 by Honorable Justice M.B. Idris as a justice of the Court of Appeal to reach that point in the trial. That is quite some time. The scenario presented above called into consideration the actualization of one of the enacted cardinal objectives of the ACJA 2015, and that is to say, speedy dispensation of justice. Actuated by zeal to attain these objectives, perhaps, on the 2nd day of July 2018, the President of the Court of Appeal, purporting to act under Section 396 sub 7 of the ACJA, issued to Honorable Justice M.B. Idris, Justice of the Court of Appeal, I emphasize Justice of the Court of Appeal, his fiat to conclude the part-hard criminal matter. And that is to say, the case between FRN against Ojus Okalo and 2 others, now pending before the Federal High Court, Lagos. The fiat directed the Honorable Justice to conclude the matter before the end of September 2018. I now produce the text of the provision of Section 3967 of the ACJA. Now, the matter journeyed its way up to because of the learned trial judge, following that fiat, went back to the Federal High Court, concluded the trial, and convicted the accused persons. There was an appeal to the Court of Appeal, and the summation of the decision of their lordships at the Court of Appeal, in spite of their attention having been drawn to very, very salient and applicable case decisions of the Supreme Court, like Ogbunyi and Okudo and others. They heard that, yes, though those laws decisions are still extant, but they tried to distinguish the applicability of those decisions from the current case. Now, the matter eventually came to the Supreme Court, and the Supreme Court did not leave out any details in pronouncing on the unconstitutionality and the nullity of that provision of the ACJA, emphasizing the supremacy of every provisions of the Constitution of the Federal Republic of Nigeria, which is enacted in Section 1 of the Constitution. Now, the Supreme Court posed a question. It says, on what constitutional authority does the National Assembly or the President of the Court of Appeals stand to grant this dispensation to the Honorable Justice M.B. Idris, JCA, to continue to act as a judge?
3,000 Americans. 17 states reported their highest number of infected.
It's also the question as to the legislative virus of the National Assembly to purport to oust Section 1, subsections 1 and 3 of the Constitution, which emphatically enacted the supremacy of the Constitution above every other enactment in Nigeria. That is exactly what the National Assembly set out to do after the cycle of legitimate constitutional amendment. Section 3967 of the ACJA was erroneously dressed by the National Assembly with a non-existent pretense of superiority over the Constitution. For a starter, the Supreme Court held that the Criminal Justice Act, which I believe must have been a typographical error on the part of the PCA, but that is the seeming statute that was cited in the letter of the Fiat. They pronounced that that enactment does not exist in the corpus juris of Nigeria and that it is void. And now went further to state the point that the law as stated in Ogbunyi and Okudo remains intact and applicable. Now, the Supreme Court, after considering, the Court of Appeal, after considering those precedents are still, that those precedents are still extant, they opted to be satisfied with the reasoning that the provision of Section 369, sub 7 of the ACJA specifically permits and authorizes the Honorable Justice M.B. Idris to sit in the lower court as a judge of that court for the purpose of concluding part-hard criminal matters commenced but not concluded by him before his elevation to the Court of Appeal. For that short moment, their lordships reasoned and held that the ACJA could validly supersede a provision of the Constitution. They omitted to remember that in 1982, when the Electoral Act 1982 enacted a time limit in Section 129 sub 3 and 140 sub 2 thereof, within which the court must deliver their judgment in election petition proceedings, the Supreme Court rose to the occasion and declared the nullity of that enactment, which sought to fly in the face of Section 33 sub 1 of the 1979 Constitution. See the case of Unongo against Epako. The Court of Appeal seemed to have adopted the stance that once the ACJA has enacted it, it is valid in its explicit ouster of any other law, because the expression used in that provision of the ACJL is notwithstanding any provision of any other law. In this appeal, the Supreme Court posed and answered the question thus: has the law espoused in Ogbunyi and Okudo, cited in the with approval in our Lion Limited against SC Nigeria Limited, changed since 2015 upon the enactment of the ACJA? The Apex Court answered that question in the negative. After explaining the law on the internal workings of the Court of Appeal and the Federal High Court, the court pronounced that the President of the Court of Appeal is not empowered to share that statutory function with the Chief Judge of the Federal High Court. The President of the Court of Appeal does not have any powers in law to direct any judge of the Federal High Court to hear and determine any matter pending before the Federal High Court. He also lacks powers to issue any fiat or permission to any judge of the Federal High Court to conclude any part-hard matter pending in that court. Now, there were so many other salient pronouncements from that court in various areas of law, but I've chosen to highlight these ones because of the paucity of time. Now, the next case I identified is the case of Kelly against FRN. This case also offers a harvest of decisions which offer guide on the interpretation and application of the ACJA 2015. At page 544CD of the report, the Court of Appeal Abuja Division, per the lead judgment of His Lordship Honorable Justice P.O. Ige, held thus: the Federal Capital Territory Court Sentencing Guidelines Practice Direction 2016 cannot supersede statutory provisions contained in Section 27011 and 15 of the Administration of Criminal Justice Act 2015. The main plank of the decision of the court in this case is the constitutional validity and the application of the provisions of the ACJA on plea bargain. On the meaning and nature of plea bargain, the court held that the plea bargain is a negotiated agreement between the prosecutor and a criminal defendant, whereby the defendant pleads guilty or no contest to a lesser offense or to one of the multiple charges in exchange for some concession by the prosecutor, usually a more lenient sentence or dismissal of the other charges. Their Lordship also held that it is also termed plea agreement, negotiated plea, or sentence bargain. The fact that played out in this case was that the appellant entered into a plea bargain agreement with the prosecution, wherewith he was to be convicted and sentenced only to 6 months imprisonment in return to his forfeiture of the proceeds of the crime. But at the trial, when he pleaded guilty, the learned trial judge adjourned for sentencing. In between the adjournment for sentencing and the actual sentencing, it became known that the learned trial judge intended to impose a heavier penalty against the defendant. Consequently, the defendant opted to withdraw his plea of guilty and rescind from the plea bargain agreement. The learned trial judge felt that that could not happen. In the first instance, that having convicted the accused person, he became functus officio on the matter. Now, when the matter came on appeal, the Court of Appeal emphasized the point that the basis on which the plea of guilt was entered is the anticipation of the lesser penalty, which was agreed upon. And they upheld the right of the defendant to withdraw from the plea bargain if the agreement is not fulfilled as agreed. At pages 538 to 539, their lordships held that though the trial court is not a party to the plea bargain, nonetheless, plea bargain section 270 sub 10 of the ACJA nonetheless empowers and endows the trial court with limited jurisdiction and powers to examine critically the plea bargain agreement to ascertain whether the defendant admits the allegation contained in the charge to which he has pleaded guilty and whether the defendant entered into the agreement voluntarily and without undue influence, among others. Now, thank you. We set out the other pronouncements in that case, which are of importance. Now, we moved to the case of, charge number NSD LF 122C of 2019. The example in that case was that the provision of section 162 of the Administration of Criminal Justice Law of Nasarawa State. The accused person was charged, and during the pendency of the trial of the charger, he applied for bail, but the court refused to grant him bail on 3 occasions. Reason, the court was relying on the provision of section 162, which regulates bail, and subsection G there says it excludes any offense involving sexual misconduct, bodily harm or any kind, or affecting the well-being of a child. In the ongoing case, the trial judge refused to grant the appellant bail based on that section. Now, the medical report, which was placed before the court, did not contain any incriminating evidence against the accused person. In other words, the expectation is that at the end of the trial, there is no likelihood of guilt being pronounced. But the court has held the accused person in detention for almost 3 years now. Now, my worry is that our criminal justice statutes do not contain any provision for compensation of any citizen for delay and imprisonment for whatever duration. If at the end of it all, he is pronounced innocent after all, maybe by the Apex Court. Cases in point include the case of Ebufo against the state, where it took 19 years of imprisonment before the Supreme Court pronounced the appellant innocent. And also the case of Mwale against the state, where the appellant suffered a detention of 23 years before his innocence was pronounced upon. I come across the judgment of the Federal High Court in another case unreported, where the issue of police brutality came up under fundamental right enforcement procedures. The notable point here is that His Lordship stood to the occasion and awarded 17 million naira against the police officers to be paid jointly and severally to the applicant. I reason that decision is a sample to be followed by trial courts in ensuring that the hope of the common man is protected by the court, as is expected. The NSAS protest has proved that the downtrodden will not forever be cowardly in their response to institutional repression. Suppressive and repressive actions are the surest indicators, incubators for the outcries against the law and considered authority. Diverse opinions are being expressed over the mass protests. A lot of opinions are towing the path of convenience and positions of their authors. One may dare ask whether the time can ever come leaders of government power can afford to kill all protesters. The intrusion by mischief makers into the peaceful protest should be seen as a pointer to the failure of the leaders and the rulers to respond timelessly to the demands of the protesters. Public protests per se are not abominable. For the wise leaders, it should serve as a useful barometer for testing the efficacy of the policies and actions of the government. There is the wise saying that if a king hopes to be powerful, he must develop very wide ears. The wide ears enable the king to hear the conversation of the ants. The ears of a ruler are his officials and his servants at all levels. For example, it should never be assumed that the function of the DSS is limited to hounding dissentient opinions and actions of citizens. It will never be well for the ruler if the aides isolate him from the realities on the ground. The operatives should ultimately be guided in their actions by the spirit of the Constitution of the nation. That is the ultimate bargain between the leaders and the electorate. For example, can any justification be found for the failure to draw the attention of the president to the unfortunate fact that palliatives meant for the public are hoarded in various warehouses across the nation? The discovery of this fact by the hungry citizens does not commend the love of the citizen for the government. True and true, the worst enemies of the government are those officials and agents who screen off the truth from the president. It is more likely that good governance will reduce the crime rate in the nation. Distrust against the ability of the government on the matter of care for the dignity and well-being of the citizen is the surest source of resort to self-help. All said and done, it stands to be admitted by all discerning minds that the innovation now being put in place by the courts and the statutes, even if delayed, are laudable and welcome. What we need to need is for the players from all sides of the divide to weigh in to ensure that the desired objectives are attained. I referred also to the case of Nnajiaofor against FRN, where the court also made some laudable pronouncements. Now, in terms of our legislative developments, we identified some provisions of the Police Act, and we commented on those that are acceptable, those that are commendable, and those that are not feasible. I concluded by, in conclusion, we said we can see from all the foregoing that we have manifested a desire to improve our criminal justice delivery system nationwide. The new Police Act 2020, which repealed the Police Act Laws of Federation 2004, is a welcome and laudable backup to the laudable provisions of the ACJA. We are yet to verify if the desire is backed up by the will and capacity to reap the desired fruits of the laudable provisions. Like the ACJA and the various ACJL, or the 36 states, we are yet to find out if these new provisions will survive the supremacy of the Constitution of the Federal Republic of Nigeria when tested. This may well be seen as a delayed response to the lamentation by Honorable Justice T. Akinola Agoda. Thus, the state of the entire criminal justice system in Nigeria prior to 1998 was deplorable. Various researches, studies, and the publications dating as far back as 1960s presented evidence of the appalling situation of human rights violations that characterize every stage of the criminal justice process. The problems identified include arbitrary arrests, delays in trials of cases, overuse of remand by both the police and the courts, which incurred in other problems such as prison congestion, widespread violation of due process, safeguards, and the fundamental rights of accused persons, as well as excessive use of custodial sentence by the courts, which again resulted in prison congestion. Research findings and indeed official records indicated that the overwhelming majority of prisoners have always been awaiting trial. This was called from the paper titled The Crisis of Justice, taken from Oko Seeking Justice in Nigeria Society, 1986. Now, if as far back as that time, Justice Akinola Agoda had so lamented, one should now agree that the reaction which we find in these new laws should be commended and should be improved on whenever the occasion arises. I conclude by stating that enactment of laudable safeguards against violation of the citizens' right is not enough unless they are backed up by a collective will and a public courage to enforce them. Section 1, sub 1 and 2 of the ACJA command us to ensure the attainment of the objectives of the Act. Thank you.
Permit me again to ask you to again give another resounding applause for the lead presenter, Mr. D.C. Demigwe, Senior Advocate of Nigeria. Thank you very much.
Thank you, Mr. Chairman.
Another well researched paper. I don't know, before we proceed, have you people, the audience and our participants, observed in paper 1, E.C. Ukala, Senior Advocate of Nigeria, devoted a entire paper to legislation. And when it came to the case of Ude Agu and the Federal Republic of Nigeria, he didn't go far, he just mentioned it, but gave us a distillation of all the legislative provisions and the enactments. And then on this paper too, I don't know whether you have observed, is a surgical judicial analysis of case law development. And that is the application of what has the court said about these laws. So that's to show us the kind of development and update. So when the court speaks, the National Assembly, the legislature will listen. They have to amend. And that was why in my remark, I was tempted to think back to those days of jurisprudence when Oliver Wendell of the Boston School, of the Yale School of Legal Positivism, said that the law is the prophecies of what the court says the law is. So if there are pronouncements of the court, that remains the law. And it's a kind of indication for our lawmakers to see that and do the necessary amendment. So I want to say thank you very much for these well-researched paper, going outside even your jurisdiction to unreported decisions in other areas like Nasarawa. It shows the level of industry you have stretched yourself to. So on behalf of the foundation, we want to thank you. We appreciate your industry. Thank you very much. And we have one of the interveners just came in while the lead presenter number 2 was going on. My brother of the Inaba, Obiagu, Chino Edmond Obiagu, Senior Advocate of Nigeria, is of the LEDAP. So that is the legal coalition for the enthronement of criminal courts. You are welcome. We are moving to, we have 2 capable and able interveners here. They want to throw in some things and chip in for us to consolidate and let these thoughts digest properly, intellectually and practically. They are ready, and they are with us in the house here. I have the privilege and honor to call on my brother Sam Ologurisha, Senior Advocate of Nigeria. He will take the first bite in the next 15 minutes to discuss as per his paper. The floor is for you, my brother. Thank you.
Mr. Chairman, distinguished panelists, my learned friends, ladies and gentlemen, I will restrict myself purely as an intervener. So I will not go as detailed as the 2 distinguished lead panelists. But let me quickly say that we are living today in terms of world changes. A new system of life and activities are emerging. Our duty as a people is to understand these changes and to utilize them for human development. The role of the state is to understand the challenges of globalization and attempt to respond appropriately. Therefore, the topic of today is an attempt by the state to respond to the challenges of new system of life and activities and globalization. Cognizance of the fact that the National Assembly has the legislative competence to legislate for the maintenance and securing of public safety, public order, and providing, maintaining, and securing of public supplies and services as may be designated by the National Assembly as an essential supplies and services. The foregoing constitutional provision, specifically Section 11 of the Constitution, is manifestly lucid as to one of the primary functions of the government which is the enactment of laws for the maintenance of public law and order. When does criminal procedure comes into play? Criminal procedure is the method laid down by law for bringing a person who is alleged to have committed a crime before a court of law for trial. It also deals with the method to be adopted by the court of trial, the powers of the court of trial, the right of appeal of a person convicted of a crime, and the right of appeal of the initiator of the proceeding, that is the prosecutor. Finally, it deals with the rules governing the procedure in appellate court. But in tackling all of this, we must be mindful of the constitutional provision relating to fair hearing, because that will be the anchor on which every procedural step will be tested. Any procedural step that falls foul of the constitutional provision relating to fair hearing is bound to be struck down. And of course, in the course of our discussion this afternoon, the lead panelists, they've taken us through some of the judicial intervention, where some of these provisions fell short of the provision relating to fair hearing. Now, my intervention will focus on Administration of Criminal Justice. Act 2015 is the pivot of contemporary development in criminal procedure in Nigeria as of today. Of course, we do know that before 2015, we have different criminal procedural legislations, the CPA, the CPL, the CPC. So the ACJA was an attempt to put everything in perspective and harmonize them. I will talk about specific intervention that this legislation has brought to bear. Now, what are some of the innovations brought by this legislation? One of them that I identified was the innovation relating to speedy dispensation of criminal justice. The realization of speedy dispensation and administration of criminal justice is one of the cardinal purposes for which ACJA was enacted into law. It is so important that Section 36, subsection 4 of the Constitution guarantees a defendant's right to fair hearing within a reasonable time. Specifically, it provides thus: whenever a person is charged with a criminal offense, he shall, unless the charge is withdrawn, be entitled to fair hearing within a reasonable time by a court or tribunal. Now, needless delays in criminal justice delivery has caused grave injustice in many cases, particularly where defendants are detained for many years before they are convicted or acquitted of the allegation levied against them. The rate of awaiting trial detainees in our correctional facilities nationwide is very high and has occasioned severe overcrowding of correctional services centers across Nigeria. Even without the fault of any of the parties or that of the court, some of the institutional bottlenecks also aided in no small measure in the delay in the dispensation of criminal justice. So ACJA has come to play in mitigating some of these lapses. Now, a lot has been said about the intervention relating to elevation of judicial officers, magistrates, and trial de novo. Indeed, the second lead panelist, Chief Denwegwe, has done a good job on it, and I do not intend to bore you with it. Suffice to say that the decision of the Supreme Court in Ude Jones against FRN is a welcome decision. It should be commended, and of course, it is only a legislative intervention by way of constitutional amendment that can bring that provision back. Anything short of that will not work. Now, another area of intervention on ACJA is the provision relating to timeline and duration for hearing and determination of a case. Now, This provision of a timeline or duration within which a criminal case must be heard and determined is important, having regard to the provision of Section 36 of the 1999 Constitution, which I earlier reproduced. It provides that trial must be done within reasonable time. It did not define what the phrase reasonable time will mean or means. Given this lacuna, the court have only helped to fill in some of the space by preferring some judicial intervention. Hence, in Egbo against Agbara, citation provided, and of course the case of Ariori and Elemo, citation provided. The Supreme Court in Ariori and Elemo said that fair hearing therefore must mean a trial conducted according to all the legal rules formulated to ensure that justice is done to the parties to the cause. Reasonable time must mean the period of time which in the search for justice does not wear out the parties and their witnesses, and which is required to ensure that justice is not only done but appears to be to a reasonable person to be done. And I equally cited the case of Okeke and the state, Joshua against Darie. It is in the light of this that I particularly feel gratified that the legislature has made some intervention, specifically Section 110, 111, 221, 306, 382, 396, subsection 2 and 3, subsection 5, 6, and 7 of ACJA. Specifically, Section 110 of ACJA provides for a timeline in which criminal trial must be commenced and concluded in magistrate court. And we must admit that the magistrate court remains one of the arm of the judiciary where almost all awaiting trial, all the criminal cases are conducted. It requires that such trial must commence within 30 days of filing and be concluded within a reasonable time. It further provides that where trial is not commenced within stipulated time, that is the 30 days, and concluded within 180 days of arraignment, the particulars of charge shall be forwarded to the chief judge with reasons for failure to commence or conclude the trial. It is safe to conclude with respect to criminal cases in magistrate court that, according to ACJA, reasonable time means not more than 180 days after arraignment of the defendant. That is my submission. As for a case of information in the High Court, Section 382 of ACJA dictates that the chief judge shall take appropriate steps to assign such information filed to a court for trial within 15 working days after filing. When the information is assigned, the court shall within 10 working days issue trial notice to the witnesses and defendants, and where the defendant is in custody, a reproduction warrant properly endorsed by the judge to ensure the defendant's appearance in court on the day of arraignment shall be issued. The section also further provides that the chief registrar shall ensure the prompt service of the notice and information not more than 3 days of the date of issuance. Of course, we have similar provision in Section 111 of ACJA, which required the Comptroller General of the Nigerian Correctional Services to make return every 90 days of all persons held in prison custody for more than 180 days after the arraignment of such suspect. As beautiful as all of these provisions are, I think the challenge is that of implementation. And I think that is the area we need to emphasize. Now, another area that interests me is the area of interlocutory appeals and stay of proceeding and hearing and determining objection with substantive case. Now, if you look through the cases, particularly the cases of Joshua Darie and all of those line of cases, you will realize that most times trials were stalled. So this intervention was meant to limit that. And our appellate courts have had cause to deprecate such ploys. For example, in FRR against Babalola Borishade, reported citation cited, his lordship Nwese GSC had this to say. Before concluding this judgment, we observe that the interlocutory appeal of the third accused person against the ruling of the trial court epitomizes the frustration of trials at first instance, which our adversarial system of criminal justice unwittingly perpetuates. It actually speaks ill of our criminal jurisprudence. The trial of the accused persons, which commenced in 2008, had to abide the lower court's determination of the said interlocutory appeal, a decision that prompted the appellant's appeal to this court. In effect, since 2008, that is 7 years ago, proceeding at the trial court had been stalled to await the outcome of the appeal against his ruling. So sad. Happily, AGJA have come to the rescue by making provision aimed at curbing this. Of course, the relevant provisions are provided, Section 221. Yes, sir, I will definitely make it, sir. Section 221 and 396 of Section 2 of AGJA. While Section 221 of AGJA provides that the court shall not entertain any objection during criminal proceeding on grounds of an error or imperfection, Section 396 of Section 2 thereof provides that though objection may be raised at any time before judgment in a criminal case, the trial shall not entertain or rule on such objection until the time judgment is to be delivered. Let me say that some of these provisions have not been tested. I'm aware there are cases where lawyers have challenged this particular provision on the ground that where the judge has taken submissions on objection, such a judge is bound to rule. But we are waiting some of the decision of the appellate court. I'm aware in election matters, we have similar provision. And I know the lead panelist, Shifukala, had cause to raise such objection in one of the election cases where the election tribunal, deferred its ruling after taking submission of counsel in an election petition. And I think the appellate court said once the trial court had taken such submissions, they are bound to make a ruling. I do not know whether such principle will apply in the criminal trial. Of course, one other area that interests me, even if that is the only one I will say and close, is the one relating to confessional statement of suspect. Now, and this takes me to provisions of Section 15 subsection 4 and provisions of Section 17 subsection 1 and 2 of AGJA. Now, Section 15 subsection 4 provides where a suspect who is arrested with or without a warrant volunteers to make a confessional statement, the police officer shall ensure that the making and taking of the statement shall be in writing and may be recorded electronically on a retrieval video compact disc or such audio visual means. Section 17 subsection 1 and 2 of AGJA provides where a suspect is arrested on allegation of having committed an offense, his statement shall be taken. Subsection 2 now says such statements may be taken. Now the word here is may be taken in the presence of a legal practitioner of his choice, or where he has no legal practitioner of his choice, in the presence of an officer of the Legal Aid Council of Nigeria, or an official of a civil society organization, or a justice of the peace, or any other person of his choice, provided that the legal practitioner in this subsection shall not interfere while the suspect is making this statement. The question here is whether the right donated to a suspect or an accused person here can be enforced, and where there is an infraction by a police officer in the course of taking a statement that will automatically render inadmissible such a statement. The Court of Appeal, one way or the other, has taken some decision in respect of this matter, and I cited some in my paper. But of course, I will want to draw our attention to the decision in Shas against FRN. It's a decision of the Court of Appeal, Lagos Division, reported in 2018, 13 Nigeria Weekly Law Report, part 1635. pages 50, page 50 especially at pages 65 to 66. What the Court of Appeal said here, while relying on the earlier decision of the Supreme Court in Owuruke against COP 2015, 15 Nigeria Weekly Law Report, Part 1483, page 557 at page 576, paragraph B to D, where Rodvivo JSC had this to say: confessional statements are most times beaten out of suspects, and the court usually admits such statements as counsel, and the accused are unable to prove that the statements were not made voluntarily. A fair trial presupposes that police investigation of crime for which the accused stands trial was transparent. In that regard, it is time for safeguards to be put in place to guarantee transparency. It is seriously recommended that confessional statements should only be taken from suspect if and only if his counsel is present or in the presence of a legal practitioner. Where this is not done, such a confessional statement should be rejected by the court. That was the Supreme Court in this case. Now, this case was cited to their lordship in Charles against FRN. And of course, the trial court, in my view, rightly said what his lordship, Justice Bible, said was so bitter, and he was not bound to apply the obiter of the Supreme Court. But of course, this is what the Court of Appeal said. The trial court, in essence, treated the above pronouncement obiter. I think, with due respect, the trial court missed the point. The dictum was quoted by the appellant counsel to show the state of the law or lack of it on making and taking of a confessional statement by the police or other investigatory authority, and to show the mischief of the legislature set out to cure by enacting section 15.4, 17.2 of ACJA 2015. Given the foregoing, I hold that the word may in the said provision carry a discretionary or permissive meaning will not suppress the mischief the provisions are aimed at curing, nor will it advance the remedy for it. It will also not add force and life to the cure. Rather, it will add strength to the mischief, and that will not be pro bono publico. Given the objective of the provision to give a permissive coloration to the provision will mean that the legislature gave a cure to the mischief with one hand and also took away the cure with the other hand. That will reduce the provision to futility and defeat their purpose. Courts are to adopt construction that will bring out the purpose of the legislation. That was the decision of the Court of Appeal in this matter. I will commend that decision to each and every one of us. I think the legislature did their best in all their intervention in ACJA, and I think it's a good development in our criminal jurisprudence. I thank you for the opportunity. God bless.
Gentlemen, can we put our hands again together? That was that is serious intervention by the intervener. And what they did was to take an aspect, ACJA. If you look at his presentation, he just brought out, if you permit me to use the word, the text time.
I'm not a biologist.
No, we're not biologists. He brought out the text time. So, fine nitty-gritties that you require to master in ACJA excellently. I want to thank you very, very much for the time taken to do this, and it's a plus for us to have this as our material behind us. And the case he has just cited, they are very, very apt in looking at these provisions. They are still developing, and the way the courts have treated this position, so that they can be very good guidance for us. Once again, on behalf of the foundation, thank you, my brother, sir. Gentlemen, can we now move to our last intervener, our brother Chino Obiagu, Senior Advocate of Nigeria. He will again also be speaking to us from the source material he has with him to bless us and to lift us in this discourse. So the floor is open for you.
Thank you very much, Chairman of this session. Thank you very much, and I want to thank the Foundation for this great job sustaining this discourse. I want to commend previous Learned Brothers Silt, who've made very profound exposition of recent development, both legislative and judicial, in the criminal law and criminal procedure law. I'll make a few comments on the submissions they've made, and then look at 3 areas of judicial development in the last 1 year. I mean, talking about the last November when this the second conference held until today. The key developments in the area of criminal law and criminal procedure is the Administration of Criminal Justice Act. We all know this is a new baby of criminal justice reformers, and we're glad that as today, 31 states have adopted the ACJ into their laws, and that's a major legislative development, because it means that we are gradually attaining uniformity and harmonization of criminal procedure in this country. We do hope that by the end of next year, the remaining 5 states will follow suit. But there is a caveat, because it appears there are a lot of discrepancies in the provisions of the ACJ laws in the state. So if you move from one state to another, you see different provisions. And that creates a problem, a challenge for criminal justice practitioners, because if you move from one state to another and you see different law, it creates lacuna. The key essence of criminal law is predictability. And when criminal practitioners cannot predict the procedure, it creates a lacuna. An example is what my learned brother Glorious Ogo just mentioned, section 15 and 16 of ACJ, which is replicated in section 9, subsection 3 of ACJ Lagos, or section 13, subsection 3 of ACJL Anambra State. Every provision of ACJL, the laws, had that provision about electronic recording of confessional statements. But some states use the word may, as the Federal Act did, and in some states like in Anambra State or or Lagos provision, the word shall be used. And I'll come back to that very shortly. But I want to say that in adopting Administration of Criminal Justice laws, there are 4 models that has emerged, and states are following those 4 models. The first is the Lagos model. The Lagos State ACJ was the first. It was enacted in 2007 and revised in 2011. As a matter of fact, when we were preparing the bill, because I was chair of the working group that prepared the bill, the ACJ bill in 2003, under the, when Shibai Ojo was Attorney General of the Federation, the then Solicitor General of Lagos State, Fola Towori, was a member of the committee. And once we finished, he took it back to Lagos. And of course, the Attorney General of Lagos State then was Yemi Osinbajo. And they cleaned it up and adopted it in 2007. And they've made a lot of improvement. And by 2005, we did a survey, my organization, Legal Defense and Assistance Project, and the United Nations Office on Drug and Crime, UNODC, on how long it takes to litigate a criminal case from point of arrest to judgment, an average case. That was in 2005. And we found out that the report is uploaded in the UNODC website and also on our website, that it took an average of 44 months from arrest to judgment. In some states, it was higher than that. In some states, it was almost 50 months. In others, about 39 months, like in Lagos. When Lagos adopted the 2007 ACJL, we conducted another survey in 2012, that is 5 years after the ACJL, and we discovered that in Lagos State, the period has reduced from 39 months to 22 months. The reason being that the ACJL has introduced interventions that reduce delay and speed up proceedings, including investigations and transmission of case file from police to the office of DPP, which is the main bottleneck. So having abolished holding charge and introduced remand proceedings, it helps to reduce the time from 39 months in Lagos to 22 months. In Anambra State, which was the second state to adopt ACJ. It adopted ACJ in 2010. We didn't see such significant reduction because in 2012, when we did the survey, it reduced from 42 months in 2005 to 39 months. So a period of just like 25% reduction. The reason being that infrastructures that Lagos State put in place were also put in place in Anambra State. Now the point we're making is that different models of ACGL provide different levels of progress. Now, apart from Lagos model, which you can see in Anambra, ACGL, in Ekiti, ACGL, or Ondo State, these are the earliest ACG state that adopted ACGL. Ekiti adopted in 2013, Ondo State in 2015. You can also see the Kaduna State model, which many of the states in the southeast and north central adopted, such as Plateau State ACGL and Adamawa State, follow the Kaduna model. There's also the Kano State model, which you see in Yobe State ACGL, in Bauchi, in Nasarawa. The main feature of Kano model is that it incorporated criminal jurisdiction of the courts, especially including the Sharia courts, into the ACGL, so that both the personal and territorial jurisdiction are all defined in the procedural law. Finally is the federal model, ACGL. A lot of states are adopting the ACJ Act itself in total, and we see that in Delta State, in Rivers State, and Enugu State. Now, when you have different models of adoption of criminal justice law in different parts of the country, it creates its own challenges, because you move from one state to another, you see different provisions. The purpose of ACJ in the first place was to harmonize criminal procedure across the federation so that there will be predictability. Now, having said that, I'll move to judicial update. But before then, I want to commend my learned brother Sek Okala for mentioning the Suppression of Piracy and Other Maritime Offences Act. It's a very important provision that we have not really brought to limelight. This act criminalizes crime at sea. And remember that in our criminal law, a crime has to be committed in the territory of Nigeria. And the maritime territory of Nigeria is 13 nautical miles into the high sea. So sometimes there's also a confusion among prosecutors whether a particular crime of piracy, was committed in Nigerian waters or international waters. Now, what this act has done is to define the territorial water for criminal jurisdiction and has enlarged it. So once it is targeted at Nigerian flag, a Nigerian flagged vessel, or a vessel destined to Nigeria, then the crime will be committed, even though it is committed in international waters. And that has clarified that point about the ambiguity about territorial jurisdiction of piracy. But one remarkable thing is that that act has contributed in moving Nigeria towards the abolition of the death penalty, because it provides that where there's a piracy, even with arms, even where there's an armed robbery on the high sea, and the person is convicted, he can be sentenced to life imprisonment. Now compare that with Section 1, Subsection 2B of the Robbery and Firearms Tribunal Act that provides death sentence for similar offense committed not at sea. And there are so many other provisions of our law. For instance, the Prevention of Terrorism Act provides for life's imprisonment for terrorism act, even if it's resulting in death, even if it's resulting in multiple deaths, it provides for life imprisonment. In other words, our legislature is beginning to listen to us, some of us that are pro-life, and begin to move away gradually from death penalty for offenses, even when they result in homicide. Now, I'll look at judicial attitude to recent development in ACJ, and there are so many of them, and these have been highlighted by Dewinga and Okala, and also my learned brother Sek Odoronsegun. But I'll look at three areas, because of time. First is what the electronic recording of confessions, which the last speaker has also mentioned. But let us trace the history of judicial intervention in that area. When the 2007 law was enacted in Lagos, Section 9, Subsection 3 provides that statements that are confessional must be recorded in electronic form or, made in the presence of a legal practitioner. You see the same provision in Section 14, Subsection 3 of ACGL in Anambra State. And indeed, all ACGLs had that provision, similar provision. Now, when the first case to come before the Court of Appeal Lagos was actually in 2011, in the case of Ismaila Fatoki and people of Lagos State. I've cited it in my paper. It is a case that I personally litigated at the Court of Appeal. The admissibility at the trial court of a confessional statement that was not recorded in video or attested by a lawyer. And the trial court overruled us and convicted the Mr. Fatoki on those confessional statements. At the Court of Appeal, the court said that the lack of compliance of Section 9, Subsection 3 of Lagos law, rendered the statement a nullity. And on that account, Mr. Fatoki and two others, because there are three sister cases, were discharged and acquitted. Well, in 2 years later, in 2016, similar case came before the Court of Appeal, which is the case that my brother has also mentioned. Joseph Zia and people of Lagos State reported, the citation was cited in my paper. And there, Justice Oseji, who was, as he then was, he was one of the justices that was elevated to the Supreme Court, very eruditely exposed the issue of criminal evidence. In fact, he said in that case, in Joseph Zia and people of Lagos State, that evidence law can only be regulated by federal enactment. So a state enactment that Administration of Criminal Justice Law of Lagos State cannot be used to exclude a confessional statement respect to its inadmissibility. That admissibility of evidence has to be regulated by the Evidence Act 2011, and sections 28 and 29 has regulated how confessional statement will be admitted. But he now went on to say that the question raised is that when there is non-compliance with section 9.3, what is the effect on that confessional statement? And my lord concluded that that statement is of no moment. In other words, it may be admissible, but it is worthless. No way should be attached to it. And we associate ourselves with that submission, without judgment, because if you exclude, the exclusionary rules of evidence is regulated by the Evidence Act, but the issue of weight can be regulated by the procedural law or the discretion of judges. Now, that is commendable, and the Court of Appeal in Lagos has followed that decision until 2018, when the case of Sondo Kondo and people of Lagos State came before it. It's reported in 2016, Federation of Weekly Law Report of Nigeria, Part 2851. A different panel of Court of Appeal, Lagos Division, held that a confessional statement that does not comply with Section 9, Subsection 3 will not be thrown out if there are other independent evidence to confirm the confession. Now, if you read that Sondo Kondo, which was also a case I litigated personally at the Court of Appeal, we disagree with that caveat because it is not seen in the legislation, but we have appealed against that decision to the Supreme Court. And we do hope that the Supreme Court will use that opportunity to pronounce on this issue, because no case of the Supreme Court had decided on the issue of electronic recording of confessions, whether the court will throw it out altogether or simply consider it in terms of evaluation of evidence. But I must mention, yes, sir, I must mention that in interpreting confession, these provisions, the Court of Appeal, Abuja Division, has given us a limelight of where to go to. They have used what they call beneficial interpretation of statute. In case of Nigeria and Federal Republic of Nigeria, citation provided. In that case, the Court of Appeal said that when a statute provides a duty that is to a benefit of a citizen, then that provision, even though prescription word is used, it should be interpreted as mandatory for the benefit of that citizen. That is the latest development in that area. Therefore, the use of word may in section 17 of ACJA has been interpreted to mean shall in Nigeria and FRN. Now let me go to the next issue I want to raise, judicial development, is on the question of plea bargain, section 270 of the ACJA. Now, section 270, subsection 18, has provided that when a judgment is given on the account of plea bargain, then it is not appealable. Now, the Court of Appeal, Abuja Division, has held that that provision is unconstitutional. In the case of Shinaka Promise and Federal Republic of Nigeria, citation is provided. Of course, it is a very welcome development because you cannot exclude appeal against a judgment of a court, even though it's a judgment is by consent, by settlement, or by plea bargain. Of course, in the civil procedure rules, if it's a consent judgment, you need to appeal with the leave of the court. So the third issue I want to raise before I conclude on the issue of Udogo, which is I'm going to express my own opinion on it before I conclude, is the question of section 306 of ACJA, which is perhaps the most controversial provision of ACJA, which provides that there shall be no stay or proceeding of a criminal trial on account of interlocutory appeal. Now, Section 306 simply wants to stop the mischief of lawyers going to stop trial, application for stop proceedings while they are pursuing an interlocutory appeal. The Court of Appeal and the Supreme Court had consistently upheld the validity of Section 306. In fact, the nail was nailed in the coffin in the case of Metu and Federal Court of Nigeria, 2017, citation was provided, where the Supreme Court said that there's nothing contradicting the right of appeal in that provision. In other words, when there's a judgment, when the interlocutory ruling is given in a criminal trial, the appeal can be lodged, but that should not stop the proceedings. The proceedings should continue. Now, if at the end of the day, the person loses the case, he can roll up the appeal in the final appeal. In order to, he uses the mischief rule in terms of what is the mischief of that provision. And I think since Metu's case, any other case that has come on challenging Section 306 has been thrown out by the Supreme Court. And we think that is a progressive interpretation of that provision. Now, finally, on Udogu's case, which is reported in the media as also use of Carlos provision, the Supreme Court said that Section 396, subsection 7 of ACJA, which permits a judge of the High Court who was elevated to the Court of Appeal to come downstairs to the High Court to conclude a part-heard criminal matter, that provision was unconstitutional. In other words, a justice of the Court of Appeal cannot exercise the power of a judge of the High Court. That is the decision. And he relied on the case of Okudo and Ogunyinya, exactly, which was an erudite decision of the Supreme Court, where a justice of the Court of Appeal was elevated to the Supreme Court. And within that period, before his swearing in, he gave a judgment, and the court said that judgment was a nullity. Now, with due respect to the Supreme Court, and we express this, that decision, in my own respectful opinion, was wrong. Because our law is replete of provisions that have allowed justices of the Court of Appeal to exercise the powers of a judge of the High Court. And we give instances here. There's Section 16 of the Court of Appeal Act that provides that where a court hears an appeal, it can make an order that a judge of High Court could make. It relied on Section 22 of the Supreme Court Act that provides that where a Supreme Court hears an appeal, it can make an order, it can take evidence and make an order of a trial court. We rely on Electoral Act and other provisions that provides that a judge of one court can exercise the power of a judge of another court. We do not see any limitation in the constitutional, any contradiction between Section 3967 and the Constitution. As a matter of fact, a provision of a statute will be contrary to the Constitution under Section 1, subsection 3, if it limits the provision of the Constitution. If it contradicts the provision of the Constitution, it does not, and the case law is replete, it does not contradict the provision of the Constitution if that statutory provision enhances, elaborates the provision of the Constitution. And that is what Section 3967 has done. What it has done is to enhance the power of the Court of Appeal without limiting the power just of the Court of Appeal to make, to come downstairs to conclude a part-heard matter. In any event, what is the contradiction? The Court of the Supreme, if you read the judgment of Jembe Eko in that case, my Lord first of all relied on the fact that a wrong act was relied upon to issue the Fiat, Criminal Justice Administration Act, and said that was unknown to law. If my Lordship had struck out that Fiat on that account, it would have been okay. But having concluded that, my Lord then went on to say, well, even if a proper act was actually used, was that contradictory to Section 240 of the Constitution? Our respectful opinion is that it is wrong for my Lord to hold that Section 396 of 7 was unconstitutional because it does not limit or contradict the power of the Justice of Court of Appeal when he is elevated from the High Court. Now, there have been suggestions, and my learned brother has also said so, that the solution is legislative intervention, that the legislature can amend this law and incorporate it into the Constitution. But you also know that the process of amending the Constitution is also very tedious, and we do hope that an opportunity will arise again for the Supreme Court to revisit itself in seeing that this Udogo and Ferren is set aside. Because the implication is that there are close to 50 to 70 cases where elevated Justice of Court of Appeal has come downstairs to conclude trials. And if we allow this to allow the Section 396 to be avoided, then we may have defeated the mischief it was sought to amend, to deal with in the ACJ. So I want to thank you, sir, for giving me the opportunity to expatiate on these issues, and thank the foundation.
Well, I say like we have done before, can we just give him another resounding appreciation? Thank you very much, Tabiagu, Senior Advocate of Nigeria. That was another test time. This time around, it really went deep. And I'm so happy for this lead paper 1 and 2, the two discussants. They've taken every aspect, pieces them, for us to learn and really benefit us. Thank you for the industry. In fact, the chronicle of all those cases, those appeal cases, I think we should note them because they'll be helpful to us. Those who are against, you pick the other one. If you're on the other side until the Supreme Court pronounces on it. And that's the beauty of it, really. And then, before we move forward, we want to thank you very, very much. And then I've had your view on the Carlos case, we normally call it, Udogu. Well, if you look at the jurisprudence behind ECHO's reasoning, take time to read it very, very well. With the great respect, he did very fantastic reasoning. And I think the answers, like we all agree on, like with the National Assembly, after that decision, what prevent the National Assembly within some few months to cure that defect, remove it from ABJA, take it to the constitutional provision, and settle the matter so that we can, and that's the issue I raised, that in between these interludes, what happens? So these are some of the burning issues I'm sure the foundation at the end of the day, they articulate and put some views forward for our people in power to look at. Thank you very much. On behalf of the foundation, we appreciate you and thank you for that industry. While we were going on, before, while the section was going on, my Lord Justice well, we always say electronic evidence. He started that electronic evidence and became the authority in Nigeria. That is where angels first to tread. If you are not versed, then you will just be, you will be swimming. So you must have to know your onion. My Lord, we welcome you. We salute your contribution and your association. Welcome, my Lord. We are still within our few times before we round up this section. But this is just for other intervenants. We haven't received any, but except if my Lord has just a few minutes or you wanted to intervene on this, although this is not your, we are waiting for you tomorrow. Yes, if you have any questions, please, can we let's know so that we can use the time now to deal with it. There are questions. The lead presenter 1 and 2, they are still online. Our discussants, the intervenants are here. So if you can if you have your questions, we can quickly go through within the time before we round up this section.
Mr. Chairman, sir.
Yes.
Yes, I wanted to react to. Am I free?
Yes, please.
Thank you. I was looking at the last intervener's contribution on the decision on Udogo. Reference to Section 16 of the Court of Appeal Act. Now, we are familiar with the principle of law that where the law has enacted a procedure for doing an act, then that procedure must be followed. The Court of Appeal doesn't just wake up and invoke Section 16 of the Court of Appeal Act. It does so under stipulated situations, which is quite different from a situation where the Supreme Court examined the meaning of a federal high court vis-a-vis the meaning of the Court of Appeal and the meaning of the justices of each of those courts before coming to the conclusion that it reached. I don't think it was the proper case for the application of Section 16 of the Court of Appeal Act as he has suggested. That's just the point I want to take on his very wonderful contributions he has made, I must confess.
Thank you very much. Thank you.
Just a little.
Mr. Chairman, sir.
Yes.
Okay, I don't know whether I can be heard on that point as well.
Yes, please.
Okay. Now, I really thank him for fantastic analysis he did there. But you see, the idea of patching bags when they are so old does not prevent them from leaking. We will continue to patch, and the bags will continue to leak until we hold the bull by the horns. As far as I'm concerned, to a large extent, you may, well, I don't want to use the language of calling the AGJA to some extent a contraption, but the truth of the matter is that a number of the provisions there cannot stand the scrutiny of the Constitution. If we want to do something, let us do it right. As far as I'm concerned with the decision of the Supreme Court in Metu's case, Section 306, I hold a view that the Supreme Court is wrong and that they will, I hope, in the future, have the occasion to revisit that decision. Section 306 encroaches into the inherent jurisdiction of the court. Yes. It was on the same basis that Upper Court's case was decided, because the court was of the view that in view of the fact that the Constitution has already, under Section 6, given the powers to the judiciary to decide the cases the way they feel will attain justice. It is not possible for an ordinary statute of the National Assembly to remove that power from them by directing them to do their job within a specified time. That was the basis of Apako and Atenkunongo. Now, the same thing runs with Section 306. So it was just a sentimental issue. The court trying to align with the so-called fight against corruption, speedy determination of cases, and so on. That is what led them to deciding Metu's case the way it was decided. As far as I'm concerned, Metu's case falls entirely within the same compartment as Section 396 sub 7. And the Supreme Court should have used that opportunity to pronounce on it so that at the appropriate time, the National Assembly can amend the Constitution if that is the way we want to go. Until the Constitution is amended, most of those provisions are suspect. So I'm in total agreement with my brother Silk, Dewigwe SAN, that Section 396 sub 7 was rightly struck out. And until the Constitution is amended, it has no place. There is no defense using Section 22 of the Supreme Court Act, no defense using Section 16 of the Court of Appeal Act, because those are for matters already before the Court of Appeal. They are not to enable the Court of Appeal descend to the High Court and sit as a High Court judge. When a matter has already been taken to the Court of Appeal.
Thank you. Thank you. You see, I think
the Court of First,
okay,
but it will sit at the High Court. So that's why I'm of the view that the decision in Udogu is a correct decision, and Metu needs to be revisited. Thank you.
Thank you very much.
Chairman. Chairman.
I'm coming.
Yusuf Ali wants to talk.
Oh, okay. Just a minute. Just a minute. Now, if you look at the 306, section 306 and 308, if you are looking at Metu, inherent power of the court, when there is a clear statutory provision, you cannot revoke inherent power. And that is why the cases of Vaparaku and all those ones, you discover that at the time those cases came, there were no express provisions. So when there were constitutional provisions...
No, sir. They were. Because that provision said it has to be, you must decide within this period of time.
Yeah.
That was the
exactly. The court, as at that time, said it was an infringement. But as at that time, there was no express provision. If you look at it, thereafter there was an amendment. And that was the amendment. When that amendment came, it's like the AFPP against Goni and all those cases we did. The Court of the Supreme Court said that it's like a court of, Rock of Gibraltar, which cannot be moved. So if that is the case, it's because it was expressly provided. So I'm glad you also, in the Udogu case, you have agreed, and which is the, in fact, it's infragilitatis for a Court of Appeal judge to go and wear the robe of a high court and come back and appear. You know, it's unheard of. Let's not go into that area, because if we want to look at it in the other way, it's scandalous. So, my brother, Yusuf Ali, please, you have the floor. Are you there? Hello? Hello? Yusuf Ali? Hello?
Hello?
Are you there?
I am here. I am here.
Yes, we are listening.
Now, Mr. Chairman and the House, I want to thank all of you for this good work. On the Udogu matter, I think I side with EC and DC, that is Okada and Benigwe, Senior Advocates of Nigeria. You see, the law, I said this in the morning when I was presiding at the morning session. You cannot be looking at the law as it ought to be. You must look at the law as it is. And if you look at the law as it is, you can't but agree that the Supreme Court was jurisprudentially correct the way it interpreted the law. So, that's on Udogu. On the debate as between Aparaku, Nongo, and Section 306, with due respect, Udogu, the Aparaku and Onongo were interpreting express provisions of the then Electoral Act, which the section which stipulated that the court must give its decision within X time. In spite of that provision, the Supreme Court still came back in Aparaku and Onongo to say that provision was an infringement on the powers of the court. These are the Constitution, which says a court, after final addresses, has 90 days to decide cases. So Section 306, look that from that side, can be situated in the same perimeter. It says court cannot grant stay of proceedings. Now, we must, at all times when we do our things, we must also relate back to where we came from. All these serious inherent powers still reside in the courts in England and in most Commonwealth countries. So we cannot, because of expediency, throw away well-established positions of the law. Because the problem is that the military psyche is affecting us. Because during the time of the military, any issue they found, even if it's something, they just made the legislation, rightly or wrongly. And I want to say with all respect, we should not be amending the Constitution as if we are amending a local government by law. The Constitution is the ground law. Everything cannot be in the Constitution. So, for me, every time we say something, Section 306, put it in the Constitution. Section 3976, put it in the Constitution. What will be left? There will be no court. Courts are there to exercise maximum power and authority in accordance with the Constitution. So I want to caution us that we should not encourage the legislature to intervene by putting matters that are ordinary laws and put them in the Constitution. Because tomorrow, when we now discover that we are wrong, then it will be more onerous and more difficult to effect the necessary amendments.
Thank you very
That is
much.
my caution.
Thank you.
Thank you very much,
Thank
Mr.
you
Chairman
very
and the House.
much. Is Okutekpa online? Before then, but Mala Yusuf Ali, yes, sir.
Yes, sir, I'm here.
Yes, sir.
American Constitution, you know, up to now, they are still having amendments. From number one.
I'm not denying that.
Yes. So, it's patch job all over the world. After all, they said they are the bigger of democracy. So if they have a Trump is trumping there. So how can we not have amendment? We cannot have anything that is holistic. Nobody can besage anything. Anything that comes, we take it as it comes and then amend. For example, the Supreme Court has spoken. The National Assembly will go there and make it. Okay, look at during the 12th to 3rd, the issue of 2/3 of 19 and the fraction. It caused problem, despite the dissenting judgment of Kayode Eshoji as it then was. What did the National Assembly do? They go back to the drawing board and say, if you have a fraction like this, it should be approximated to the next year whole number. So, so if we leave that state like that without, and don't forget the National Assembly, we just mentioned just now, Udongu was decided about a year ago now. Up till now, nothing has been done. So if we keep quiet and say, all right, let us go on as it is, this justice will be too much. So let it not be seen as if the judges are making law. No, they are not. They are just interpreting. But by interpreting, they have set down the pace for the National Assembly to take the clue. Thank you, sir.
Chairman, please don't misunderstand me. I never said we should not amend the Constitution. I'm just saying it's not every issue on which there has been a pronouncement that then you go and amend the Constitution. Because the danger there, that's what I'm saying. Of course, I know that the American Constitution is amended from time to time. But it's not everything in America they put in the Constitution.
No, if there's a pronouncement of the Supreme Court, for example, on an aspect of that Aja, and it concerns the National Assembly, we cannot leave it in limbo. They have to take it off. If the Supreme Court
with respect to you, it's not more in limbo with respect to you. The Supreme Court has spoken about how Section 396. Supreme Court has spoken about how Section 3967 should be interpreted, and that is our. So it's not in limbo. That one totally is not in limbo.
It's okay. It's because we're almost off our. Is Okutekpa still online?
I'm here, sir.
Okay.
Don't allow the brain to talk. In the morning, he didn't come for our session.
But it's not delivering.
Good afternoon, sir.
He's not delivering.
Good afternoon, I send my apologies.
He cannot deliver his paper here. This is a different section now.
I just returned from the Supreme Court, and I also sent message to my president, and I apologize for what looks like insubordination. I couldn't have done so to Malam Yusuf Ali, the only Malam at the bar. I apologize, sir.
No, yeah, intervene. You say you want intervention. Just for
all right.
Not your paper, because we cannot take your paper now. We don't have.
Yes, my intervention, sir, will come out from the debate I just raised now. The aim of every law is attainment of justice. Now we have clamored for limitation of times in the Constitution, in electoral jurisprudence. And today we are all living witnesses to judgments that are coming in electoral matters that are completely devoid of justice. We must be very careful to avoid ad hoc arrangement, even in our Constitution. Yes, the Udegu's case had come. Yes, people are saying that justice had not been done, but we will need to be very careful the way and manner we put our laws. For instance, if we put section 308 or 306 in our Constitution and create that there should be no objections to competence of charges, we're all living witnesses to what happened in Nigeria. All I need to keep my learner brother ST Ologorisa in prison today is then to go and allege some unnecessary criminal allegations that are completely unfounded, and you now file an application to challenge the competence of that process before a court of law, and then you are taking through the entire gamut of trial. What sense do we have? What is the basis of making laws to say you cannot challenge the competence of a charge unless the entirety of it is taken at the conclusion? Why should a man go through trials for an allegation that otherwise he would not be convicted at the end of the day? We look at the investigations that are being done by our law enforcement agencies today. They are wishy-washy investigations. Now, my brother ST Ologorisa has discussed extensively about this section 17 and 15 of AJA. You will discover a lot of today of this issue of money laundering. All over Nigeria, money that were meant for political campaigns. The moment you are a political opponent, my president, you are carrying your hands to cover my face, and I want to see your face because I sometimes appreciate seeing you if you are agreeing with me. Hello, sir.
Hello. Go ahead. You mean me?
I'm not covering your face. Setting the screen.
Yeah. Yes, sir. So
no,
I think that we should be very careful about the principles we set even in our lawmaking. Now you discover that this question of allowing lawyers to be available, in most of the cases we had the matter in Kano, and the trap that President JB Dawud the SAN set was hunting us there. We allowed the statement to go in, and at the end of the day, when we started cross-examination, the EFCC man said, oh no, this is the kind of thing that JB Dawud did to us in Makurdi. I said, we will do it because we are the apostles of JB2. You took a statement, you didn't record it, you didn't allow lawyers to be there. We should be allowed, because if we are not allowed lawyers to file their trades and argue like this, and then you make this into watertight, and say at the end of the day, you take everything at the conclusion, we are likely to get more injustice. And I draw attention to section 285 of the Constitution that has now fixed time frame to conclude election matters. We all know that you have plenty witnesses. You are to call as a respondent or as a petitioner. But because of this time frame, and when you even go to the tribunal, they are giving you less than the number of days that you are required to prove your case. Yeah, at the end of the day, we'll get injustice.
2 minutes more.
Now,
2 minutes.
Now, please, sir, let me draw our attention to some other area that I get worried about these practice directions. Yes. There are a lot of practice direction going on now. I'm sure most have discussed it.
Because we are sitting our time, please. 2 minutes.
All right, so let me say that having been given just 2 minutes, all I need to say is to thank the Rule of Law Development Foundation for the privilege to make this intervention. My paper is there. I've aired my views in it. I hope that it will be published on the website of the Rule of Law Development Foundation. I thank you, my leaders, my learned friends, and Chief Ukala and DC Denwigwe, and all of our elders. God bless you.
Thank you very much, Mr. Kutekpa. That's a kind intervention. I just wanted to point out here, you know, the concept of justice has defined all schools of thought in the faculty of jurisprudence. Because a job with justice to A might be injustice to B. So there are so many things. One of the things what I saw there is that we lawyers, when it comes to, because the issue now, the consensus is that, oh, we should be wary of laws. We should be wary of this. How many of us have gone to the National Assembly? Mr. Obiagu has been there just now. He mentioned how I saw in his paper when they were tic-tanning on Abja. Many of us, I'm sure JS, if he's asked to come and deliver a paper in National Assembly, he won't go. And with the great respect, because there's no money there. It's not
Nobody has invited me because I'm not a politician, sir.
No, because we leave these things to the
let them invite me, I will be there.
They go and hire LA, they hire some consultants that don't know anything. But then tomorrow, we are waiting. Let it bounce. When it comes, you take it here, you take it there, you tear it to pieces. But we can also make input by assisting them. So that's the bottom line of what I'm trying to drive home there. Well, in the absence of any, because we have exceeded our time, I think because it was a stimulating time, very robust moment. And I'm sure that with the way the trend is going, if we were to still spend some, it will seem as if the time is still just 8 o'clock. So, okay, just a question. Okay, I was asking for a question, please. Go ahead, because the panelists are, they're all here. Yes. Use the mic.
Okay. My name is Owo Caleb. Actually, Mr. Chairman of Session, I must say that I've benefited a lot from discussion, robust discussion today. Especially from the first speaker. My reaction comes from the first speaker.
Yes. He's listening. He's hearing.
Based on, he cited section 734 of the newcomer that was just passed into law. And that section says all offenses under the Act to be tried by the Federal High Court within the jurisdiction in which it occurred.
Yes.
Now, under the Constitution, I'm taking a cue from the decision of Udogu Jones and FRN. It's very trite in that case that his Constitution is supreme and cannot be overridden by a subsidiary legislation. Now, under the Constitution, it states that there is a one Federal High Court of Nigeria.
Yes.
Now, in this act, it's saying that the offenses can only be tried in the jurisdiction where it occurs. I want to say this: does it not offend the provision of the Constitution, where it's very clear that there's only one Federal High Court?
Well,
yes, sir. That's just my own.
If he can, he's listening. Are you there?
I'm here, but I didn't hear a word.
Okay, that's why I say you should speak up so that he's of the view that since you refer to section
734 of the newcomer, that just passed into.
Sorry for this. No, use this one. Okay, use that one.
Okay, thank you, Mr. Chairman of Section. My reaction stems from the discussion by the first speaker in the panel today. He made mention of Section 734 of the newcomer that has just been passed into law. And the said section provides to the effects that all offenses under the Act is to be tried by the Federal High Court within the jurisdiction where it occurred. Now, the Constitution is very clear that there is a one federal high court for the whole Nigeria. And taking a cue from the case of Udiogo and James, it's very clear that a subsidiary legislation cannot override the provision of the Constitution. Under the Constitution, there's a one federal high court for the whole of Nigeria. It means that an offense can be instituted in any federal high court within Nigeria. Now, under this schema, it's saying that if an offense occurs in Edo State, that offense can only be instituted in federal high court of Edo State, and it cannot be instituted in any other federal high court outside Edo State. My view is this: does it not offend the provisions of the Constitution? I just want to be clear, sir. Thank you.
Okay. Hello, Izzy.
Thank you.
Are you there? Or
Thank you very much. Really, there's not much to be said about it.
Exactly.
Because you are very right that the Federal High Court is a one constitution court. But somewhere along the line, I think the Chief Judge of the Federal High Court decided to make provisions, I think, under the rules, where it says matters that occur in a particular jurisdiction should be entertained in that jurisdiction. Definitely, whether that will override the constitutional provision is not a matter of discourse, because we all know that the Constitution takes precedence over those provisions, including the provisions of the CAMA. So it depends on how the court eventually interprets it. But the argument that, yes, the Constitution takes precedence over the provisions of the CAMA cannot be faulted. So I agree with you.
Thank you. But in addition to that, that is, I mean, agreeable.
I don't know if I may come in at this point, Mr. Chairman.
Oh, okay.
To throw some.
Okay, coordinator.
Uh-huh.
Yeah, are you there?
Yes, I say if I may just throw some light
Yes.
in the last question.
I was going to follow your case.
Yes, that's what I wanted to clear.
Exactly. Go ahead.
The position is very clear that the Federal High Court is governed by a legislation, that is the Federal High Court Act, and by the provisions of Section 19 and 44 of that Act. The Federal High Court is broken into judicial division. And the statute of the court says it's broken into judicial division. It has a specific section in the Federal High Court Act which says that where a criminal offense is committed, it has to be filed in the judicial division of the court where it was committed. And that was what arose in Ibori against FRN, where an offense was allegedly committed in Delta State, and it was taken to Kaduna to be filed under the principle of that the Federal High Court has one. Now, we took an objection that no, it will be following I've forgotten the case in the East, that you will be imposing too much responsibility on us and hardship for us to move our over 200 witnesses from Delta State to Kaduna to defend ourselves, and that it amounted to forum shopping. If the statute says that you must file within the judicial division where the offense was committed. Now, the High Court, of course, Shuaibu J, as it then was, overruled us. We went on appeal to the Court of Appeal, and His Lordship Augie JC, as she then was, together with a very strong panel, agreed with us and said that it amounted to forum shopping. And the fact that the Federal High Court is one jurisdiction does not allow it does not allow for filing of charges outside judicial division, and that it was constitutional. They appealed to the Supreme Court. Unfortunately, the Supreme Court, you know, at times, if you meet them, or when they wake up from the wrong side of the bed, they were very livid that the state could appeal against such a very mundane point, forced Rotimi Jacob to withdraw the appeal. So the existing position or the extant position of the judgment of the Federal High Court, of the judgment of the Federal Court of Appeal in Ibori against FRN. So it is a clear situation, and it's the same situation that the young man has raised now. Clearly, you cannot forum shop. You must go to the section 7, I think it's 740 of Akama was trying to comply with the position of the law. Thank you.
Exactly. That's, that, I think you're very satisfied.
Very well, sir.
Thank you very much, coordinator. And on this call, may I thank you, participants and all the listeners for this section. And thank you for tolerating me to chair this section. Forgive my inadequacies. And it will be a pleasure. Anytime I'm called upon next time to be here. Once again, I appreciate the foundation for the opportunity and the privilege. Thank you, gentlemen, and good afternoon.
Let us give the panel a resounding round of applause, please.
Thank you.
You can see we've had a robust intellectual discussion on criminal procedure. It's only that the 3 hours we had is far too short, if you agree with me, to really get into the nitty-gritty of the issues raised. But I want to start by thanking the chairman, Dr. Alex Zion, Senior Advocate of Nigeria, for managing us and steering us through this session. We kept to time, although I kept disturbing him, but he himself was conscious of time so that we can go about our daily business. Thank you, sir. Maybe next time we'll look forward to a paper from you, Dr. Zion, because I could see the time was not enough for you to speak on some of the issues that came up. I also want to thank the 2 lead presenters. They are part and parcel of the Rule of Law Development Foundation. That is the persons of E.C. Ukala, Senior Advocate of Nigeria, and D.C. Demungwe, Senior Advocate of Nigeria. Learned Silks, we are immensely grateful for you taking out the time to churn out literary work and as well as come and educate those of us who are still learning the ropes, and even for seasoned legal practitioners. I'm sure we must have benefited a lot from your papers you have discussed. To the interventions as well, we want to thank Learned Silk, Sam Olorungu, Senior Advocate of Nigeria. I'm sorry, I should know it. He's going to punish me later. But I want to thank him as well. We are sorry for the 15 minutes. I know your paper is with us. The conferees can get it. I know he only spoke to tidbits of his paper. But sir, thank you very much for your time. God will bless you. We also like to thank Learned Silk Chino Obiagu, Senior Advocate of Nigeria. He is also part of the foundation. He's been with us from day one as we are trying to contribute to the jurisprudence in this area. Sir, I'd like to thank you for your position. I know a lot of people gave you a hard time for the position you took, but sir, do not relent. I'm sure there are others that also support your position. Sir, thank you very much for your time. And to the other interventionists, Malam Yusuf SAN, DS Okutekpa SAN, our coordinator that stayed with us, and others online. We have to also thank you, the virtual conferees. I know you wish you were here to come and say, hey, I want to talk, but because of the time and because of the times we find ourselves in, because of the pandemonium of Corona, hopefully it will leave us and we'll have a fuller conference. So I want to thank everybody for the time. This is the end of day 2. We'll come back tomorrow and we have a very, very good session on electronic evidence. In fact, the lead presenter is already here. That is Honorable Justice A. Ajileye is already here. And so let us endeavor to be on time so that we can deal with electronic evidence tomorrow. And we are starting by 9 o'clock sharp. So thank you, everybody, and I wish you safe journey to your various destinations. Thank you.
Thank you very much.